Assalamualaikum warahmatullahi wabarakatuh. In this video, me, Alia Lubuk, and my two other members, Muhammad Fadil bin Arifin and Nasha Zulaika binti Zulkarnain, will be presenting on case review of Sabah Shell Petroleum Corporation Limited and another, and the owner of an or any other persons interested in the ship or vessel, the Borkos Takti 2012 5 MLG 515. The area of law that will be discussed in this video is related to law of torts, specifically in the topic of negligence. First of all, we will be looking at the summary of facts. Okay, so in this case, the plaintiffs, which was Sabah Shell Petroleum Corporation Limited and Sarawak Shell Berhad, or usually known as Shell, is a company that handles offshore oil and gas exploration and production activities in offshore areas, precisely in Sabah and Sarawak. So, in order to deliver their cargoes and necessary materials such as food, equipment, tools, machinery to the offshore platforms, they had utilized the use of a vessel called the Borkos Takti, owned by the defendants. So, both parties signed a contract dated 14 October 2002. It all started on 28 July 2004 when the Borkos Takti was on its duty to deliver cargoes at Bright Hawaii, a mobile take-up rig at one of the plaintiff's platforms. Upon its arrival, the vessel dropped an anchor to secure its position during the discharge of cargoes. However, the drop anchor snagged and ruptured the plaintiff's 6-inch underwater pipeline, which caused damages to the plaintiffs, which the plaintiffs sued the defendant for. So, the plaintiffs sued the defendant on the ground of negligence and or breach of duty and or breach of contract. The defendant argued that the damages occurred were because of the plaintiff's own fault or had been contributed by the plaintiff's own conduct. Also, the defendants contended that the plaintiffs cannot claim more than 5 million ringgit Malaysia by virtue of Clause 21, Subsection 1, Subsection B, under the contract signed between them, as well as under Section 360 of Merchant Shipping Ordinance 1950. It was argued back by the plaintiffs that they had provided the updated topographical chart for better allocation to drop the anchor, hence made the defendant or its servants or agents to be solely held liable for the damages.
So moving on to the relevant issue that we can get from the case. So the first issue is whether Shell is entitled to rely on the doctrine of res ipsa lucito. So res ipsa lucito allows a court to infer carelessness or negligence on the part of the defendant, where the claimant can show that the nature of the accident triggers both negligence and the defendant's responsibilities. And from the case, there is no dispute that the anchor dropped from the Borkos Takti and snagged the 6-inch pipeline. And if you think about it, such an incident ought not to have happened at all in the ordinary course. And that, however, defendant opposed that this is not a suitable and proper case for this court to invoke this evidential rule. So to determine whether the rule of res ipsa lucito is appropriate on the fact of this case, we need to acknowledge whether the three conditions are satisfied. And this condition will be explained by Nasha after this. So moving on to the second issue is whether the accident was caused by the negligence or breach of contract of the defendant, or whether it was caused by the error or failure or omission of the plaintiff. So in order to come to a conclusion of the case, it is necessary to examine in detail how the incident actually occurred. So from the case, plaintiff witness step 1 testified that the master in the course of the investigation demonstrated the method of parallel indexing prior to anchor drop incorrectly. However, the evidence pertaining to what the master said he did in terms of planning and carrying out the anchor drop is basically a hearsay because it is not the evidence of the truth of what the master actually did on 28 July 2004. So whether the master employed parallel indexing but performed the technique incorrectly is a matter of dispute between the parties. Also, direct evidence of the exact events, particularly on the master dropping anchor near the pipeline, were not available through the plaintiff's witness either. And in the end, after few contention, plaintiff witness and Shell concluded that the incident had occurred because of the failure of the master, and the reason it will also be explained by Nasha after this. Whether this is true as a matter of fact is not established, but the fact that such a conclusion was reached by Shell is basically admissible and also relevant to the case. And because of that, causation is not conclusively established. This is because it's not possible to conclude whether the cause of the anchor was mainly because the master failed to plot his position, or whether it was caused because the master carried the technique out correctly but failed in calculating the distance he applied when doing the parallel indexing. So we also need to consider on the events after anchor drop. So the issue of causation is not simply restricted to the events that occurred before or soon after the anchor drop, but also the events following after that. So looking at the facts, the damage is more caused by the excessive force applied when the master is trying to free the anchor from the impediment. So from this, the explanation put forward by the defendant after that is that the master and crew failed to recognize the possibility that the anchor had snagged on the pipeline. And this is not a plausible excuse or reason justifying a finding that the inference of negligence has been rebutted. So moving on to the third issue, which is contributory negligence. So the issue is whether the incident was caused by the negligence of either one of the parties, or whether the other party is contributorily negligent. So the first one is about the topographical charts, whether it provided by Shell is inadequate. So the defendant mentioned on the failure of the plaintiff to provide chartlets with safe anchoring zone as specified in the charterer's instruction. So the defendant further continues through its expert defendant witness, seeks by certain demonstration that the maps provided by Shell were insufficient. After all, having considered the competing testimonies and evidence, the court maintained that Shell did in fact produce a topographical chart showing clear and obvious presence of the oil and gas pipeline. All right. So the next contributory negligence is the role of the offshore installation manager or OIM. So the defendant mentioned that a contributory cause of the incident is due to the OIM manager at the Pride Hawaii that basically instruct the master to drop anchor on that particular day. In contrast, the defendant maintained that Shell breached the term of its contract because the OIM needs to assist the master and notify him on precise instruction or warning of obstruction. However, the decision of OIM and Shell contested that the decision of Price Silver to drop anchor lay with the master. So the master have full power of this. So the defendant contention is rejected. So the liability due to the absence of salient and direct evidence, it was concluded that Shell has established a balance of probabilities that the defendant is entirely liable in negligence for the incident. Also, there is no basis and evidence to support a finding of contributory negligence against Shell.
And now I will be presenting the ratio decidendi. In the first legal issue, the court referred to the case of Eller v. Selfridge and Co. Ltd., where a car veers onto the pavement, hitting a pedestrian, and the case of Devin v. Bunn, where a vehicle veers onto the opposite lane, hitting another vehicle on the right lane. The doctrine of res ipsa loquitur was utilized. There are some elements that needed to be fulfilled to use this doctrine. The first element is the event would not have happened without the defendant's negligence. The court held that the incident would not have occurred in the ordinary course of good seamanship, and that this amounted to prima facie evidence of negligence on the part of the master and thus the defendant. The second element is the thing that inflicted the damage was under the sole management and control of the defendant, or of someone whom he is responsible or whom he has a right to control. In this case, the master enjoyed the right to manage and control the vessel, including dropping and retrieval of the anchor, proving the second element was also fulfilled. Besides, the master was employed by the defendant, whom the defendant had the right to control. And the third element is there must be no evidence as to why or how the occurrence took place. In determining how or why the vessel dropped the anchor near at the oil pipeline, resulting in rupture upon its heaving, the court found that there was no primary or direct evidence to explain precisely what the master did on the day of the incident, as the master was absent during the trial. Therefore, the third element was fulfilled, and this case was fit to apply the rule of res ipsa loquitur. However, for the second issue, it was not concluded whether the incident was caused by the negligence and or breach of contract of the defendant, or whether it was caused by the error and or failures and or omissions of the plaintiff. Therefore, there is no ratio decidendi, as no judgment was made in this second legal issue. In the last legal issue, the ratio decidendi is that Shell has established on a balance of probabilities that the defendant is entirely liable in negligence for the incident due to the absence of salient and direct evidence. Also, there is no basis and evidence to support a finding of contributory negligence against Shell.
We can see that the judgment made by the court in solving the issues in this case was correct and fair to both parties. Why? Because firstly, the court applied the relevant rule of law with the factual metrics of the case accordingly. For instance, the application of res ipsa loquitur was established based on its required elements, and the court handled the element one by one respectively. Also, the definition of the rule was given at first, and several cited cases and several relevant cases were cited in applying the rule of res ipsa loquitur. Besides, the court took into consideration both parties' contentions meticulously in order to arrive at a fair judgment. As a wise judgment will listen to both parties before making any judgment. And lastly, the court's decision to allow the plaintiff's claim was a rational judgment on the ground that the defendant's negligence was proven, where the defendant ruptured the pipeline, which the pipeline was connected to other platforms, thus causing the plaintiff's substantial damage. Therefore, the decision of the court is wholly supported.
So similarly, there is also another relevant case that is quite similar to our case, especially in how they apply the doctrine of res ipsa loquitur. And the case is named David Celia, or Kovil Pillai Celia David versus Monorail Malaysia Technologies and Rian Berhad. And in summary, the plaintiff, very brief, the plaintiff was standing at a road divider directly below an elevated KL monorail track when a safety wheel, not anchor, weighing 13.4 kilograms from a KL monorail train which was passing overhead on a test run came off and fell on the plaintiff. And as a result, he suffered serious head and bodily injuries. So, applying res ipsa lucito, it will be safe to assert that this case require uh, fulfill all the three requirements. And the first element is that a safety wheel of a monorail train does not, in the ordinary course of things, fall off and hit person on the ground below. And the second element is the safety wheel on the train was under the sole control of the first and second defendant of their servants. And lastly, although the plaintiff could point to the safety wheel coming off the monorail train, he was unable to state precisely why the wheel had come off. Therefore, all our requirements of Repisa Lucito is fulfilled. We can apply this Repisa Lucito. So the judgment is the first and second defendant had failed to provide a reasonable explanation as to how the safety wheel had come off the train. And they only mentioned on the possibility that it had been damaged or tampered by someone. However, there is no evidence of tampering was disclosed. Negligence on the part of the first and second defendant had been proven, and therefore they are liable to the plaintiff equally for damages and costs.
And lastly, the impact of this decision of this case on future cases. The decision of this case will impact future cases that are related to negligence on professional parties. This case could be used as a supportive case in the future, like how the case of Newfield Peninsula, Malaysia, v. the owners of the ship or vessel Tanjung Pinang 1. This case referred to this shell case in using the res ipsa liquidator. In that case, the plaintiff succeeded in proving to the court that the defendant was negligent. Moreover, the decision will dictate the parties' future actions as they will be more cautious on performing their activities and job. This will also let both parties know that they can do what they can do and be exposed on which aspects can they sue someone for. Finally, other people will understand more about the principles in this case and doctrine used, as they could utilize it for future cases. Judges will also be able to refer to the judgment of this case to make decisions on relevant cases in the future, thus making this case important. That's all from us. Thank you.